competition after termination of employment. Generally, and we'll get to judicial enforcement, in the non-competition area, you need to be able to demonstrate that your former employee has left and is now either contacting your customer relationships, contacting your customers or using your former trade secrets. But the idea of a non-competition agreement is important to have within the scope of your employment relationship. And the last type of restrictive covenant is a non-solicitation agreement, which would protect against the solicitation either of your customers or of your maintained employees. And so all of these are addressed to your employees who have left your business and are moving on, and you need to protect certain vital information. As far as restrictive covenants are concerned, the general rule from a drafting perspective is that cookie-cutter agreements don't work. There are forms on the internet. They are really junk. It's a very fact-specific area, which gets a lot of judicial scrutiny. The judicial standard for enforcement of a restrictive covenant, it must protect a legitimate interest of the employer, and we'll get to what legitimate interests are. It must impose no undue hardship on the employee. I'll also get to that in a moment. And the covenant must not be injurious to the public. The harm, the undue burden on the employee and the injury to the public are kind of one and the same thing. The courts analyze those very similarly. So what's the legitimate interest of the employer? Each of these topics, again, I'll be available out there. They take a ton of time to go through. But your legitimate interest, what you can prevent as a business owner from your employees leaving and disclosing, are trade secrets, confidential information, customer relationships, pricing formulas, pricing lists, as well as your customers' particulars and requirements. With respect to the customers, when these are drafted and what's protected, you can only protect customers that you either introduced your employee to or supported during the course of their employment. You can't prevent somebody from going on to a business and then they deal with a customer who is also a customer of yours, but they had no prior knowledge of that customer relationship. They didn't support that customer. They didn't service that customer. The non-protectable interests, again, that's customer relationships that were not serviced by your former employee, and you can't use these merely to stifle competition. So merely going to a competitor is not enough for these to be enforceable by a judge. As far as the reasonable standard, restrictive covenants, as I mentioned, are evaluated on a case-by-case basis. The two biggest inquiries are the scope of the geographic location as well as the time of the restrictive covenants. The courts will enforce these covenants only to the extent that they're necessary to protect your business. As far as the geographic restraints, as we talked about the two prongs, geographic and the time restraint, geographic restraint is dependent on your industry and the market relative to your business. So again, it's a fact-by-fact, case-by-case basis. Basically, if the size of your agreement, the geographic territory, has a fairly close relationship to the territory in which you conduct business, and I'll get to that in a second, that is a legitimate geographical scope. So it's probably not applicable here, but the courts have found that the entire United States have been considered reasonable when that is an area in which you do business. There's no requirement to have a geographic restraint. You can do this on a specific customer-to-customer basis so that only your customer relations are prohibited. In other words, the employee can work wherever they want, they just can't touch your customers. Time restraints, again, this is dependent on what's necessary to protect your business. Restraints as far as 50 years have been enforced. Of course, those cases are from the early 1900s. Typically, where trade secrets are involved, 2 years is a generally reasonable restrictive covenant. In protecting customer relationships, usually a year is the standard. It could be more or less depending on what your needs and the need for heightened protection. The last thing I just want to talk about, it affects you 2 ways, restrictive covenants. You have employees who are departing and employees who are coming in. Now, there are facts and circumstances in which you hire an employee and for their tortious actions while they're employed by you, you can be liable. So it's important when hiring employees, A, find out whether they have a restrictive covenant from their former employer. Emphasize to your incoming employees that it's not a policy of the company to take in confidential information which they've received from their former employer. As far as going forward basis, advise the employee if you have trade secrets that they will be exposed to these trade secrets. Advise the importance of maintaining confidentiality, and at the inception of employment, that's when you should get the restrictive covenant signed. Again, whether it's a non-disclosure, confidentiality, or non-solicitation agreement. They can be 3 separate agreements. They can all be embodied in the body of one agreement itself. With respect to departing employees, 3 tips. Number 1, vital that you conduct an exit interview. Remind them of what their obligations are, and that you will enforce restrictions to the extent you find out they are either competing or soliciting your customers. Inquire into potential conflicts. You're not specifically allowed to delve into where their new employment is. Some employers, the retaining employers, make it a policy that they divulge that information. But if they refuse to tell you where they're going and it later turns out they're at a competitor soliciting your customers, et cetera, it goes to helping you in the event this has to go to litigation, which Kevin O'Connor will address shortly. And then after your employee departs, put both the employee and their new employer on notice that there are obligations in place, that you intend to take them seriously, and that any breach will be prosecuted and you'll seek legal relief. So my real tip here is if you don't have restrictive covenants, you need one. And if you have restrictive covenants, they should be reviewed to make sure that they fit within the applicable judicial parameters. Thank you.
Yeah, Chris brings up interesting points, and if you're sitting there saying, gee, I have confidential information and I don't have a confidentiality agreement, the good news in New Jersey is that you can still come up with one and force your employees to sign it at the threat of termination, and the courts in New Jersey have said that's okay. Also, when you think about what confidential information is, if I'm arguing against a non-compete, I'll say it's not the recipe for Coca-Cola that we're protecting here, or rocket science, with all due deference to Murata Controls here, which is rocket science. A simple thing like a recipe in a restaurant and how they make a certain dish could be confidential information. Did you ever try to get that recipe from a favorite restaurant of yours, and they won't give you the exact one because they consider it confidential? There was a lawsuit in New York about that last week, as a matter of fact. So however big or small you are, we've handled everything from startup companies with 2 partners who have hired 1 employee and put a non-compete in as recently as a month ago, right up to litigation between ADP and Intuit. I represented the current CEO of Intuit who had a restrictive covenant dispute with ADP going back about 5 years ago. So it applies to all businesses, and that's what's important to remember. There's also a duty of loyalty in a company if you don't have any restrictive non-compete clause, which says that while an employee is still working with you, they still have a duty of loyalty to you and can't do things that are contrary to your business. So you do have a little bit of protection there, although on a much more limited basis. Our next speaker is Phil Chapman, an accomplished corporate and business lawyer who is going to speak to you about LLC operating agreements, economic management, and exit strategy issues. Phil?
I'm going to skitter around, but first I want to call your attention, in case you haven't seen it. There are 3 handouts